the representative of the Chief Justice of the Republic of Ghana, Her Ladyship Justice Hafizata Amal-Boba, who is, by the way, married to a lord of the Dagabes and not a slave. My lord and brother, Justice Yoni Kulendi, the man who frightened me to pass my law exam in the first year. My lords temporal and spiritual, ministers of state, members of parliament, the Honorable Charles Kwazin, Upper West Regional Minister, Madam President of the Ghana Bar Association, learned colleagues, ladies and gentlemen, I deem it a great honor to address you this morning in my capacity as the Attorney General of the Republic. The first time I had the privilege of addressing you at an annual conference was in Kumasi in 2015. On that occasion, I spoke on behalf of the Honorable Attorney General, Marita Brew, who was then my boss. The theme of that annual conference was the rule of law, access to justice, and sustainable development, the panacea to political and economic progress of a nation state. The theme of this year's conference calls upon us to reflect on the state of our profession, the sustenance of our democracy, and the role of the judiciary in sustaining our democracy. Distinguished ladies and gentlemen, the legal profession in our country is built on centuries of tradition. The profession traces its roots back to the 19th century when the Supreme Court Ordinance of 1876 gave persons qualified to practice law as either barristers or solicitors in Britain the exclusive right of audience before the Superior Courts of the Gold Coast. According to Robin Lookham, this ordinance laid the foundation of the professional monopoly over the representation of clients before the Superior Courts of the Gold Coast that we, as a profession, enjoy today. The legal profession is more than a career. It is a calling, or what we Catholics call a vocation. Being a lawyer entails a sacred duty to uphold justice, defend liberty, and safeguard the soul of our republic. Fidelity to these principles and ideals is the insurance for the continued role of the bar as a pillar of our democracy, not just as it has been since the dawn of our independence from colonial rule. We must, however, admit that our profession stands at the crossroads. On the one hand, the Ghanaian bar has produced juries of international renown, men and women who have served as presidents of this republic, as judges of the International Criminal Court, such as my former teacher, Professor Eku Akwenhia, as leaders of international tribunals, such as Dr. Thomas Mensah of the International Tribunal for the Law of the Sea, and as scholars whose writings have shaped jurisprudence across the Commonwealth. On the other hand, we must acknowledge the shadows that threaten our credibility. The ordinary Ghanaian continues to lament the delays of our courts, the prohibitive cost of litigation, and at times, the perception that justice is not blind, but is for sale. These perceptions, whether exaggerated or not, erode the legitimacy of the rule of law and our democracy. The rapid expansion of legal education has created both opportunities and burdens. We celebrate the growing number of young lawyers, yet we must also address the uneven quality of training, inadequate mentorship, and limited opportunities for practice that confront them. These challenges drive my conviction that we must, as a people, re-examine our approach to legal education. In my 2015 address to the bar in Kumasi, I stated as follows, quote, "Every generation reproduces itself, and we, the current generation of lawyers, must reproduce ourselves so that the legal profession can continue to exist and flourish in Ghana in aid of the rule of law and democracy. And we can only do so through legal education, and particularly professional legal education. Professional legal education in Ghana is at a crossroads. After several decades since the establishment of the Ghana School of Law, the model of professional certification that institution represents is out of tune with the realities of modern Ghana, especially the demands of the market for legal services. Yet, the model continues to be operated despite the writings on the wall. With all due respect, this is leading us to a situation, this is leading us as a country and as a profession down the wrong road. We have, in simple terms, taken the wrong turn, the crossroads, just like we have done several times in our life as a country. But there is still time for us to get it right. My hope is that what I am going to say here today will generate some discourse in the public sphere and within professional circles, as well as the academia, and prompt decision makers to start thinking about reforms that would avert an imminent crisis. End of quote. In pursuit of the reset agenda of the government of His Excellency John Dramani Mahama, I will be submitting the Legal Education Reform Bill to Cabinet this month. The main objective of the bill is to widen access to legal education and to provide equality of opportunity to our countrymen and women who aspire to become lawyers. The bill will, hopefully, achieve this objective by introducing a one-year law practice course to be administered by accredited law faculties. Upon attaining the Bachelor of Laws degree from an accredited university, a student will then enroll in the law practice course in the same university for one academic year. The law practice course will focus exclusively on the subjects that are practical in nature: civil procedure, advocacy and legal ethics, and the law of evidence. These will constitute the examinable courses to be taken at the National Bar Examination that will be administered by a Council for Legal Education. In essence, when enacted, the bill will cut down the duration of legal education from 5 to 4 years. Though the current monopoly of the Ghana School of Law will be abolished, the transitional arrangements of the bill will retain the school as a stopgap mechanism for current students and persons who have qualified to practice law in common law jurisdictions and wish to enroll as lawyers or members of the Ghana Bar. When the current cohort of students complete their training in 2027, the school will adopt and teach the syllabus of the law practice course to prepare students for the National Bar Examination. Distinguished learned friends, in the public discourse surrounding these reforms, I've heard the argument being made about there being too many lawyers in our country. Indeed, some amongst us have argued, without any empirical data, that the reform of legal education would open the floodgates, resulting in an oversupply of lawyers and a concomitant reduction in the quality of lawyering. I disagree. In his groundbreaking article titled "The Market for Legal Services in Ghana," in number 8, Review of Ghana Law, April 1976, Robin Lockham recounts the story of a legal practitioner who complained as far back as 1904 that the Gold Coast Bar is overcrowded. I'm quoting him. At the time that our learned colleague made this observation, there were just 11 lawyers in the Gold Coast. 8 native lawyers, That included the famous Mensa Saba, Casely Herford, Bannerman, Ribeiro, Addo, and Buckle, as well as 3 English lawyers. Now, I didn't want to tamper with the record, so I'm taking the names directly from the article, by Robin Luckham. So when he said Addo, I didn't know whether that was our former Chief Justice Akufo-Addo, but so you notice that the names have just been taken without, referring to their, first names. Understandably, as Luckham rightly observes, when the question whether there is an oversupply of lawyers is raised by the profession itself, it is because of the worry that increased competition for business undermines professional standards. But supposing, without admitting, that the quality of legal services can be increased by erecting entry barriers such as we have now, according to Luckham, this will be achieved at a significant cost to society. In his view, this cost to society, quote, would be felt in 2 ways. First, in the reduced availability of lawyer services to ordinary people, which is a serious matter in a country with a lawyer to population ratio of 1:15,000. That was in 1976. And second, in the monopoly rent that the legal profession commands. The fewer the lawyers, the higher the average cost of their services to the litigant. Ladies and gentlemen, we must, however, remember that law is not an abstract instrument for the elite. As Justice Samuel Kofi Dateba once reminded us, the ultimate justification for law lies in its service to society. If our practice does not make justice accessible to the market woman, the farmer, the laborer, and the vulnerable child, then we'll have failed our sacred duty to our country. The relationship between law and politics in Ghana has always been intimate. Lawyers were central to the nationalist struggle, drafting petitions, leading debates, and championing the cause of independence. Since then, lawyers have been indispensable in shaping constitutional governance, whether in drafting the 1992 Constitution, defending human rights in times of crisis, or mediating in moments of national tension. Yet, our role in politics must be guided by principle, not partisanship. When lawyers descend into the arena of raw politics without restraint, we risk undermining the very foundation of our professional credibility. We must remember that our allegiance is first and foremost to the Constitution and this republic, not to transient political interests. Over 3 decades have passed since the adoption of our Constitution. During this period, our republic has tested and continues to test the resilience of its democratic institutions. In doing this, the bar has played a crucial role in assisting the Supreme Court to interpret and enforce the Constitution. But outside the courtroom, the advocacy of the bar as a professional group has lacked consistency, bringing into question its adherence to principle. Ladies and gentlemen, when in 2015, an Article 146 petition was received by the Chief Justice in relation to the former chairperson of the Commission on Human Rights and Administrative Justice, Madame Loretta Lamte, the bar failed to speak out about process. In the run-up to the 2016 elections, the then opposition New Patriotic Party engaged the Electoral Commission in court battles over the voter identification system. This gave rise to the Abu Ramadan line of cases. Immediately upon assuming office in 2017, an Article 146 petition was filed for the removal of the chairperson of the Electoral Commission, Mrs. Charlotte Osei, and her deputies from office. The bar saw no basis to speak out about compliance with due process. But in recent times, the bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice, Mrs. Gertrude Araba-Tokono. Ladies and gentlemen, the honest question we have to ask ourselves is, what changed? The three petitions aforementioned touch and concern office holders of three constitutional bodies critical to the sustenance of our democracy. The independence of the three institutions has been guaranteed by the Constitution. The three occupants were all women of significant repute and members of our noble profession. The three committees established pursuant to Article 146 complied with the constitutional procedure to the letter. And yet, the bar found its voice only in relation to the third petition. Coincidentally, the voice of the bar amplified the voice of the opposition. The lawyer in politics must be a voice of reason, moderation, and constitutionalism. The bar must speak out not to please governments or opposition parties, but to defend the rule of law, the independence of the judiciary, and the rights of the ordinary citizen. The Ghana Bar Association is not merely a professional body. It is a moral compass of the legal fraternity and a key pillar in the construction of our constitutional democracy. As Lord Denning once wrote, and I quote, "Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking that the judge was biased." The same applies to the bar. Our authority as a profession depends on public confidence that we stand above the fray of narrow partisanship. Let us therefore be the conscience of the Republic, fearless when governments overreach, impartial when opposition agitates, and always faithful to the sovereignty of the people under the Constitution. And talking of sovereignty, we should desist from the temptation of inviting foreign interference in our internal constitutional processes. As a professional body, there is absolutely nothing wrong with forming relationships with like-minded foreign associations. Such relationships are necessary for cross-fertilization of ideas on professional matters such as standards. That is where it should end. Interference in constitutional politics risks violating the principle that sovereignty resides in the people of Ghana, in whose name and for whose benefit the powers of government are to be exercised. My distinguished colleagues, the task before us is clear. We must renew the spirit of the profession. We must strengthen ethical discipline within our ranks. A few errant lawyers can tarnish the credibility of the entire bar. The Ghana Bar Association must be vigilant in holding us to the highest standards of integrity. We must deepen access to justice. Legal aid must not be a token gesture. It must be a living reality for the poor. The state is committed to resourcing the Legal Aid Commission, but the bar must also embrace pro bono culture as part of its civic duty. We must modernize our justice system. E-filing, case management reforms, and digital court process, records are not luxuries. They are necessities if we have to build a judiciary fit for the 21st century. We must reclaim our role as guardians of democracy. The voices of lawyers must not fall silent when constitutionalism is under threat, whether from the executive, the legislature, from political parties, or even from within us. Madam President, my lords and learned friends, the quasi-constitutional nature of the bar places it squarely in the center of our state bureaucracy and by extension, our politics. This deprives the bar of the requisite independence to be truly professional. This constitutional grant of privilege, or if you wish, of right flies directly in the face of the equality of treatment that ought to be accorded to all professional bodies in the country in terms of Article 17 of the Constitution. Of course, the Constitution was written by and for lawyers. However, and excuse my language, this self-serving ingratiation of the bar into the bureaucratic structures of the state flouts the principle of equality. So, Madam President, I'm inviting you today for us to re-examine critically this model of the relationship between the bar and the state that puts it at the center of bureaucratic politics as well as the politics of the country. The destiny of Ghana is tied to the integrity of a legal profession. If we stand firm, this republic will stand firm. If we falter, this republic will stumble. Let us therefore recommit ourselves to the ideals of our forebears: justice, integrity, freedom, and service. And let the bar of Ghana remain, as it has always been, the living conscience of the nation. Bless the Ghana Bar Association, and may God bless our homeland Ghana and make all of us great and strong. Thank you.
Shall we do it again, please? We shall now have an address and formal opening of the conference by the representative of the Acting Chief Justice in the person of her Ladyship Justice Hafisata Amaliboba. Shall we please welcome her?
Thank you very much. I bring you warm greetings from His Lordship, Justice Paul Bafuboni, Acting Chief Justice of the Republic of Ghana. His Lordship is unable to be here in person due to other pressing engagements, so he has delegated me to read his